Good morning, everyone. Happy holidays and welcome to Elville and Associates and the law offices of Gary Greenwald's December Client Care Program webinar. We're pleased to have you here today. My name is Jeff Stauffer, Community Relations Director with Elville and Associates. You being here today reflects your strong commitment to your planning and the continued updating and maintenance of your plan in which you've invested so much time and effort. The mission of the firm's client care programs is to provide you with the comfort and assurance that your plans will work no matter how your goals and situations may change, and to ensure planning remains consistent with changes in the law. Our firms are the only two in the state to have our client care programs accredited through the Client Care Academy in Boston. So they are comprehensive programs, and we want you to take advantage of all they have to offer. As for today, we have much to cover. We have three presenters: Managing Principal and Lead Attorney Stephen Elville, Principal Gary Greenwald, and Elville and Associates Attorney Michael Joseck. All have worked very hard to put together a comprehensive program for you today. And we also have door prizes to give away from our recent client event on-demand video presentations at the end. We'll also be taking a break in between each presentation for a few minutes so you can get up and stretch and get coffee and what have you. You also have the opportunity to pose questions throughout, and we'll encourage you to ask those questions, and we'll get those answered in a timely manner for you as well. So Steve will start us off by discussing end-of-year planning strategies to take away from the election. Michael will talk about tax fundamentals in estate planning and administration. And Gary will take us through a trustee workshop. So to start us off, Steve, I will turn it over to you.
Well, thank you, Jeff, and good morning, everyone. Jeff, before you go away, I believe you have some prizes to give away at the end.
We do, yes. I mentioned that. We are going to have door prizes from the client event, and I will do that at the end of today's presentations.
Thank you.
So
well, good morning again, everyone. Thank you, Jeff. And warm holiday greetings to everyone. I'm referring to my notes here because we don't have a lectern, as I normally do when we meet at the community college. And there won't be any lunchbox lady today, unfortunately, but we're going to adapt and overcome and continue to persevere here during the pandemic where we have to meet virtually. I'm wishing all of our CCP family members, both Elville and Greenwald, all the love and happiness of the holidays. So I'm sorry we cannot be with you in person. And we hope that you are staying safe and well during this crisis and the continuing pandemic. And we thank you for your commitment to learning, continuing education, making sure your plans are going to work as intended, and just generally being on top of things. We really commend you for that. And we could not do it without you. I want to thank Jeff for all of his hard work. Without Jeff Stauffer, we could not put on these events. So Jeff, thank you for all your sacrifice and your hard work. And as Jeff mentioned, I'm very proud to introduce our associate to you today, Michael Joseck, who is our estate and trust and estate tax and gift tax associate. Michael is going to talk to you today about Forms 1041 and estate tax returns like the 706 and 1041. Michael has a lot to offer. So I think you'll be very, very happy to have the information that Michael will share with you today. I want to encourage everyone in the CCP, both Elville and Greenwald, to please take advantage of your CCP membership. Make sure that you're updating your documents. For example, not only changes in the law, but for example, for the Elville CCP members, I had sent out a message recently about the COVID-19 situation and certain updates to advanced medical directives about ventilation and potential experimental treatments, and making sure that our documents are effective immediately under this crisis, even though sometimes we wouldn't normally have our documents effective immediately. We want to make sure that our documents will actually work at this time of crisis. So if you haven't updated your documents in this manner, I encourage you to think about it and to let us know and utilize your membership. So this is our second CCP virtual meeting. Again, we have no wine as we did last time. And I understand from Gary that a new wine event is in progress, as many of you have requested. So just know that, again, we're going to do the very best we can virtually. By the time I get done my tax presentation here in just a few minutes, you may feel like you want to drink some wine. And I will be sorry about that in advance, but it's very important for you to understand the information we're going to share about the pending tax changes that may occur in 2021 or beyond. Now, there are two aspects of my material as we jump right in because we have so much to share with you. We want to stay on time and end on time. I want you to think about with the magnitude of the information that's going to be shared with you during my presentation. I want you to look at it in two different ways. And if you're taking notes, this would be a good idea. Part of what we're going to discuss relates to what many of you are concerned about probably, which is the potential for estate tax changes. For example, reductions in the exemption amounts for estate tax, which we are currently enjoying the big exemption amounts of 11.58 million and 11.7 million in 2021. Many of you are going to be concerned about that today. That is a valid concern, but I also want you to look at the material that you have in front of you there, that resource that of my presentation plus the others. I want you to look at it as a resource, as a continuing legal education piece of literature or material that I want you to study. I want you to review it and really absorb it because you won't be able to absorb all of it during my presentation. So look at it as resource material that's important not only for end of year 2020, but into 2021, 2022, how to deal with the potential changes, not only in estate tax, but in income tax. So with that said, I'm going to be going over the material rather quickly. So with that, I'm going to share my screen and get right into the presentation. And again, welcome to our last CCP event of the year. I am going to just minimize my screen for just a second to get my desktop where I want it to be. And then I'm going to share again, if you will bear with me. And Jeff, I'm just going to assume that I'm sharing my desktop, and I hope everybody can see it.
Looks good, Steve.
Thank you so much. All right, with that said, let's launch into this material. Michael will present after me, and we have much to cover, so here we go. So we have some critical planning issues for 2020. These are the four major categories we're going to cover with this plethora of material. Roth conversions, charitable contributions, estate and gift tax planning, which is what many of you are concerned about this morning, and a concept that we'll briefly cover called gain harvesting. Now, we know the political cycle has come and gone, or is actually still in process, but we know the presidential side of things has finally apparently been decided. And we know what direction we're going in with the Democratic Party. Now, here are the themes of the Democrat Party tax proposals. Many of you have read about this. Take this as further advisement. So additional payroll taxes, we're not going to focus too much on that today. Increases in marginal tax rates, that is something that we can expect. We're going to talk about that. Increases in capital gains rates, we can expect that depending on the situation in Georgia and who's going to control the Senate. All of this is going to be pending what happens there in the Georgia runoffs. Changes, as we discussed, in estate and gift tax exemptions and increases in corporate income tax rates. These are all potential changes. Now let's talk about this Georgia Senate runoff. We just don't know what's going to happen, right, until January comes. And as I go into my next slide, we are just not going to know until that happens whether the Democrats are going to kind of have a full palette where they can just kind of push forward, or whether there's going to be resistance with a Republican-controlled Senate. So regardless of that, we need to be aware, and many of you are concerned about this, what is the risk of a retroactive estate tax law? What if the Democrats push through a reduction in the exemption amounts to 3.5 million? Now, that's what's being proposed. And we know if they could push that through, if President-elect Biden can push that through, that's what we'd be looking at. Now, we need to know that in regular or civil law, there is no retroactivity normally. But in tax law, due to federal law, the IRS or Congress can have tax laws retroactive. So many of you are concerned about this. What if I don't do end of year planning to give away enough money to use my large exemption amounts, and now I'm going to lose it? We're going to cover that very briefly. Here's what I want to share with you after speaking to a preeminent national practice estate planning lawyer who we speak to quite frequently. And here was his opinion. And he happens to be a Delaware lawyer who practices nationally in many, many different states. Here was his opinion, which I thought was instructive and somewhat surprising, but he has some specialized knowledge in this area I wanted to share with you. So again, we are scrambling. Many of us are thinking in terms of planning before end of year. Got to get it done before the end of the year. This particular attorney advised us, he thinks that the possibility of a retroactive estate tax law back to January 1st, 2021 is extremely unlikely. Very unlikely, even less than 1% likely, because it's never happened before. Even though it could happen, it has never happened before. So that is his opinion, that there's no need to rush. Now, many conservative people are rushing to use their exemptions before end of year. We're going to talk more about that, but his opinion is there should be no rush. Now, the second most likely thing he thinks is going to happen is that the Democrats are somehow able to push through a reduction in the estate tax exemption by March or April, and or maybe September, October of next year, and that it would go forward. It would be introduced going forward, but no retroactivity. And he thinks that the most likely thing that would happen would be an estate tax change in 2022. As of January 1st, 2022, there would be a new lower estate tax exemption. So I wanted to share that with you for those of you who are very concerned about this. As what do we have to do before the end of the year? It could happen, but according to him and this national practice, it's not likely to happen. I wanted to share that with you. Now, Vice President Biden, or President-elect Biden, is proposing tax increases on over $400,000 of income. The Biden tax proposal is rather thick, so this is a summary version. So increases in Social Security tax, restoring a 39.6% marginal rate, capping certain itemized deductions. And this presentation, we're not going to talk too much at all about the PEAS limitations or the Section 199 phase out. Now, again, 39.6% rate on capital gains. That would be a tremendous increase from where we are with capital gains. Also, a discussion about an elimination of the step up in basis. This has never happened as far as the step up in basis, except one time back in the 1980s, and it was very, very temporary. So the experts that we're listening to don't think this elimination of the step up in basis, which would be huge, is going to occur. They think that Congress will kind of feel around the edges of things, but not take that step up in basis away. Now, look at this slide. It says capital gains over 1 million, there would be a 39.6% rate. So there could be an exception or an exemption from capital gain, even if they take away the step up in basis and so forth. There could be a certain amount of exemption there. We just don't know. These slides are going to be mostly for your review. These have to do with the proposed increases in the Social Security tax. Again, we're going to skip through some of these. This is a chart showing just a history of where we are in the tax brackets, and you'll see the proposed tax brackets for 2021. And I like this chart. I think it frames everything for us very well to kind of see what is being proposed, although, again, we don't know if it could be or will be pushed through. This is an example of what might happen with the cap on itemized deductions. Again, we're not going to spend too much time on that today. We have too much material to cover. This is another slide along those lines. This is back again to the issue of what would be the increase in long-term capital gains rates and so forth. Now, you'll see the red here at the bottom, and it says what might happen if we've implemented a charitable remainder trust. And we're going to cover the basics of a charitable remainder trust today. Stopping to take a deep breath for just a second. What is all of this about? This is just about being aware, being educated, and understanding that the capital gains rates, the marginal income tax rates, all could go up, and we want to understand what we're doing before we do it. So for example, if we were to implement a charitable remainder trust, what do we know about that? Well, we know that it avoids capital gain once that trust is established, but also we know that when it pays out, and most of it is going to be capital gain when it's paid out, we know that capital gain is going to be, it's going to catch up with us when it comes back to us in the form of income. So we want to be very careful if we implement a charitable remainder trust to understand that the increase in capital gains rates could affect us on the back end. So we just want to be aware of what's going on in the world of tax as we're looking at vehicles if you are charitably inclined. And we're going to talk more about the charitable remainder trust. Again, the proposed elimination of the step up in basis, we don't think that's going to happen. We don't think a Canadian system would be implemented, which has been talked about, where death is a triggering event for capital gain instead of what we've always enjoyed, which is the step up in basis at death. So we're not taking that too seriously, but it's something we have to watch that could happen. Now, let's talk about Roth conversions. That was one of our second big bullet points. Many of you are familiar with Roth conversions. Many of you are acting to go ahead and get Roth conversions done. Why? Well, because of the Secure Act and so forth. But remember that Roth conversions are now something you should be thinking about as we're thinking about the potential for income tax increases. What am I trying to point out here? And we've talked about Roth conversions so many times. I'm simply trying to point out for those of you who have never seen this before, we did talk about this in our previous two CCP meetings ago. We want to understand that given the same annual growth rates and the same tax rates in the conversion year as being the same in the withdrawal year, okay, we want to look at this chart and see that a traditional IRA and a Roth IRA are going to basically end up the same place, with the Roth IRA maybe even better than the traditional, but at least at the same place given the same growth rate and the same time period. So many of us think that, oh my gosh, if I convert to a Roth, it's going to take so long. And there is a risk involved, and that risk could be minimized through the use of life insurance or other strategies. But just as a basic premise, remember, same growth rate, same time period, same rates at the time of conversion and withdrawal, it's going to equal the same exact amount. So that's just something we want to continue to look at is Roth conversion. Why would someone convert their traditional IRA to a Roth? Well, maybe it's because of the Secure Act and what so many of us have talked about over the recent months. Maybe we want to make sure our children aren't hit with that big tax acceleration. But maybe there are tax attributes that need to be taken advantage of, such as carry forwards. Maybe we're going to try to get a lower marginal tax rate. So maybe that's one reason we're going to do it. Maybe we have funds that are outside funds that can be used and make it much more powerful for the conversion. All kinds of reasons why we want to do a Roth conversion. So it's something that we want to collaborate with your financial advisor and your CPA. If you haven't seen Roth conversion numbers and you're interested, let us know and we can collaborate with your advisor. Charitable contributions. Now, the old rule was to accelerate our deductions, and now the new rule is to time our deductions. It's an important thing to remember that under the CARES Act, 100% of your adjusted gross income in 2020 can be a charitable contribution, okay? And that is something that not a lot of people are aware of. So just be aware of that. Now, donor advised funds. These are going to be appropriate for certain people. These are powerful. Maybe someone doesn't want to spend the money on a charitable foundation, but they're very charitable oriented. What if someone wants to bunch their contributions? And we're going to talk about that in just a few minutes. The donor advised fund is a wonderful thing. So just know that donor advised funds are probably underused. They're wonderful vehicles. These are some reasons why someone might want to use a donor advised fund. And let's look at that second bullet point there. This person gives relatively small amounts to charity, and that person doesn't really benefit from itemizing. So this person might be a candidate to use a donor advised fund. And down there in the third and fourth columns, it's talking about having not to establish a private foundation, but simply using this low-cost donor advised fund to achieve your charitable intent. So just know that donor advised funds are a powerful tool for the right person. Now, we're not going to spend a lot of time on these two slides. It's talking about appreciated property. What if we have charitable intent, but we have appreciated property? Well, there may be good reasons to go ahead and donate that property. And this is a key idea, according to our CPA sources that are monitoring these new tax proposals. This is a key idea. If we have appreciated property we want to donate, this might be better than a cash contribution under the new Biden tax laws. So just know that this is something that you should keep in the back of your mind. Now let's get to the really hot item here, which is qualified charitable distributions. Many of you have done this and are doing this. Up to $100,000 per year can be donated. It's a deduction of income for your income. It can reduce or replace an RMD. And what I'm going to show you on the following chart is various ways to look at charitable contributions now, and just to see the power of the qualified charitable distribution, QCD. So for example, here is a couple, and we're just going to spend a second on this. This is Art and Alice in this example. They're used to giving $15,000 a year to charity, but they don't have very many other deductions, and except for their state and local tax deduction. So their total deductions are $25,000, but they already have a standard deduction of $27,400. So their charitable contribution is not really giving them any benefit. Not that they're maybe concerned about that, but just in this example, they're not really getting any benefit from that. But they're very, very nice people who are charitably inclined. Now, if they were to lump together those 2 years, 2020 and 2021, now they would start to realize some kind of income tax savings from bunching those two contributions, $15,000 for 2 years in a row. They're doing it all at once. That's what they would have to do to be able to get some kind of benefit. Now, what if they had appreciated property? Here they have a piece of property, and it has, they bought it for, I'm sorry, I can't see most of my screen here because of my, my video picture, but I believe in this example, we are looking at a charitable contribution of property where they bought it for $13,000 and it's worth $30,000, and now, excuse me, the other way around. Anyway, they have a capital gain of about $13,000. So if they just sold this property and contribute the balance, they're going to pay capital gains. So why do that? They could contribute this property to a charitable organization and again, have a charitable deduction for that. So this is an example of, the first example was straight gifting, and then the next one is the gift of an appreciated property. Now let's look at how that compares to a QCD, a qualified charitable distribution. So here, Art and Alice use the QCD, and they make their distribution as a QCD. And now, if we look at this chart, and I want you to study this in more detail after today, we'll see that on the left, the cash gift, if they bunch those two gifts all in 1 year, 15,000 times 2 in 1 year, and then skip the next year, they get a $4,000 benefit. If they do the 15,000 bunching and they gifted the appreciated property, they still only have a $6,400 benefit. But if they use the QCD, they have the most benefit for having given their charitable contribution. So that's what this slide is showing us. Now let's talk briefly about charitable remainder trusts. We know that charitable remainder trusts are one of the options, not only if we're charitably inclined. It does wonderful things where we can donate property to a charitable trust. That trust can last up to 20 years or over the lifetime of the beneficiaries, and then the remainder goes to charity. And when a low basis property is contributed to this trust, it can be sold and there is no tax until that tax is later distributed out to the lifetime beneficiaries. Then the balance goes to charity. So it's a wonderful thing. Many people are considering the use of charitable remainder trusts to deal with the Secure Act, as many of us have discussed with you over the last several months, because the lifetime payout to yourself and to children can best simulate the lifetime payout of a stretch out of an IRA, which has now been eliminated for most people and limited to 10 years. So we just want to review this very quickly to put this in our minds as one of the options. So there's several different types of charitable trusts. The most common is a charitable remainder annuity trust. So the beneficiaries receive a fixed percentage each year and so forth. And the term of the annuity, as I mentioned, can be 20 years, up to 20 years, over the life of the annuitants and so forth. So this is a wonderful tool. Now, what do we have to be aware of? Well, there's several types. First of all, there's a charitable remainder unit trust. We're not going to take up a lot of time going through the various types today because you have seen this before in several of our presentations. The most common, of course, is the annuity trust. Sometimes there are advantages to using some of these variations, okay? But the general purpose of the charitable remainder trust is that the donor does not realize gain or loss when the property is transferred to the trust, okay? And then that donor is able to receive an income for himself or herself and their spouse and even children. And then we have to crunch the numbers and see what the actual charitable amount would be. But we want to be aware, as I was mentioning earlier, okay, even though it avoids recognition and so forth, when the money comes out, it comes out in tiers. So the first distributions are taxed as ordinary income, and then capital gains and so forth. There are 3 or 4 tiers here. I believe there's 4. And these charts show what we are wanting to be aware of before we jump into a charitable remainder trust. We may want to think twice, knowing that these higher income tax rates are coming, or it may not affect us at all in our thinking. So here's an example. Again, in the interest of time, I want to make sure that Michael and Gary have plenty of time to talk. Here is an example of a retired executive and his wife. They want to create about $85,000 more of income, and he has appreciated stock. And the question here is whether or not they should sell that stock and donate some money to charity, or whether they should use a charitable remainder trust. So without spending a lot of time, you can review this on your own. We see example 1, they liquidate the stock and reinvest it and make a gift at their deaths, or they contribute the stock to a charitable remainder annuity trust. And as you look through these examples, you'll see here, the first one is they simply liquidate the stock and reinvest it and make they pay the tax and they make a testamentary gift. And then the second example is they're using a charitable remainder trust. And you'll see the power here of the charitable remainder annuity trust, assuming this person and this couple had a lot of strong charitable intent. So just know that that is available to you at any time. And if you would like to see examples of a charitable trust, we will run those numbers for you. Now, here's the heart of what many of you are concerned about today. The income tax situation is unknown. The estate and gift tax situation is unknown. We know that we are in a use it or lose it situation where we had an increase with the Trump tax cuts. We had an increase in the exemptions, and they basically doubled. And we know in 2025, the exemptions are going to be cut in half as of December 31st, 2025, if there's no congressional action before then. But with the Democrats potentially in full control, they may be able to push through what President-elect Biden has said, which is, I want to reduce those estate tax exemptions. Now, if we look at this very simply, option number 1 is to do nothing. And there's nothing wrong with that, especially with the uncertainty that we know of. So the exemptions that have doubled are going to go away and be at least cut in half as of January 1st, 2025. I'm sorry, that should be 2026. I apologize. Option number 2, and this is a very, very important point for us to understand. So I'm going to slow down here with option number 2. Let's say a couple gifted, and there are ways of doing this, and we're going to talk about that briefly. Let's say a couple gifted a pretty large amount. They gifted $5,790,000 to a trust in 2020. Let's just use that number. And in 2025 or sooner, so let's say that the Republicans are not successful in Georgia and the Democrats are able to push through a lower exemption amount in 2021. Let's say that the remaining exemption goes down to half or goes down to $3.5 million. What's important to understand about option number 2 here, even if you made this kind of gift in 2020, you will not benefit from the large exemption amount that we have now of 11.58 million. I want to emphasize that again. It's only large gifts that will benefit from the large exemptions that we have now. Even though this is a relatively large gift right here, 5,790,000, if the exemption were cut to 5,790,000 in 2021 or in 2025 or 2026, it would not benefit you and you would have no remaining exemption amount. So that's something I want you to think about. Look at option number 3. If you're a person of wealth and you could give very large amounts in 2020 or in 2021, if there was no retroactive law, those large amounts would capture the large exemptions that we have now. So where I'm going with this is, and something important for you to know, is if you are going to use the existing exemptions, you must use large amounts to capture the large exemptions that we have now. Medium-sized gifts, so to speak, even though 5,700,000 is very large, will not help us if the future exemptions are only 5.7 million or 3.5 million. I hope that makes sense, and we may have to cover that again in one of the question and answer sessions. This chart attempts to explain this. We have a certain amount of old exemption, and that was the amount before the increase. Then we had the 2018 increase of another 5.7 million, but if we don't use the increased amount, then we are stuck with the old amount or the amount that will be less than the old amount. So I hope that will make some sense. I think the best way to think of it is we must use very large gifts if we're going to take advantage of not losing the very large existing exemptions. Because if we make just, let's say, mid-range gifts, that's not going to help us pending the future reduction of the estate tax exemptions. If we use the larger amounts before they go away, there is an IRS regulation that says there will be no clawback. There is no clawback. The government will not be able to come back and take away that exemption amount from you. Also know that Maryland has no clawback on gifts within 3 years of death for Maryland estate tax purposes. Now, how are we going to do this? And I'm just going to check my time, and I'm quickly running out, so I'm going to go quickly here. We can use dynasty trusts. So many of you have established further trust for your children and loved ones. Those can be dynastical in nature, but we're talking about trusts here that are irrevocable, that large amounts would be gifted to, and those are dynasty trusts. Many of them are called spousal lifetime access trusts, where each spouse contributes assets for the other spouse. There are ways to do that where you can gift assets and still have control of them through your spouse. And we won't spend time on the bottom one there. Dynasty trusts avoid future estate tax. They do not avoid future generation skipping tax unless the generation skipping tax exemption is properly allocated. So these are some charts for your review. A SLAT, or spousal lifetime access trust. I establish a trust for my spouse. He or she has access to that. And then my children also have access to discretionary distributions. I can also have some benefit from that if we use advanced planning techniques such as Delaware or other advanced planning states. So this is a chart for you to understand the spousal lifetime access trust. We won't spend a lot of time on that. And here are some further interactive charts about that. Swap powers. What if we have assets in a trust, or irrevocable trust, and those assets are low basis assets that are going to be subject to capital gain at our death? We can swap high basis assets into that trust and get the low basis assets back out of the trust into our own name, where we can actually pass on a step up in basis, if Congress doesn't take that away, at our deaths. And we're going to go through just a few more slides here before I turn it over to Michael. So family notes. Now these are advanced planning techniques where money is loaned to a family member and they are giving you back a promissory note. And family sales, where income producing assets are sold in exchange for a promissory note. These are strategies to get assets out of your taxable estate. They will not apply to everyone or the average person, but These are things that are available to you that we want you to know about. This is a chart about how the family sale works. We won't have time to go into all of that today, but we can individually. Swap powers, as I just mentioned, this is a technique of swapping out assets, and it's allowed so that we can get low basis assets into the hands of the individual who, when they die, if the step up in basis is not taken away from us, the beneficiaries will get a step up in basis. And this is an example of a swap power that you can review on your own. A grantor retained annuity trust. This is a vehicle where assets are transferred into a trust that pays you an annuity. And to make a long story short, this is an arbitrage where if the assets in that trust outproduce the federal rate, then that amount that is outproduced is going to be a gift. It's going to stay with the beneficiaries. It's a way to get money out of your estate. And a GRAT is not going to solve our end of year problems for 2020. It's not a one size fits all, but it is something that as we go forward into 2021, if we have lower exemption amounts and you are concerned about getting assets out of your taxable estate, a grantor retained annuity trust is something that we should be talking about as a very, very sound method, especially with the interest rates being as low as they are. And an installment sale, this is where we have an income producing business or asset that can be sold in exchange for a promissory note. This is very similar to what we were just talking about. This is an advanced technique. This is something that can be done to deal with not only estate tax issues, but try to deal with the income tax issues. Generation skipping trusts are something you've heard us talk about before. These are dynasty trusts. A charitable lead annuity trust is very similar to a GRAT. So remember, we talked about a charitable remainder trust. This is a charitable lead trust. We won't spend a lot of time on that, but just know it's there for us to use as a tool. And the last thing I'm going to go over is irrevocable life insurance trusts. So remember, many of you have life insurance policies. Now that we are facing the potential for these large exemption amounts to go away, we need to get those life insurance policies and cash values out of your name so that the life insurance will not be taxed in your estate. And these are two examples where we have a surviving spouse. And in one example here, the husband had $5 million of life insurance. This was passed to his surviving spouse, and there was no life insurance trust. So in this rather large example, there was $2 million in tax, and it was basically on that life insurance policy. So we don't want the proceeds of the life insurance to be taxed at 40%, or God forbid at 55%, which was the the estate tax percentage when I was a young associate. In this next example, and I'm almost done, the $5 million life insurance policy goes into an irrevocable life insurance trust, and there is no tax on that. So we need to remove life insurance from your estate if we are facing a situation of lower exemption amounts in 2021 or beyond. Capital gain management, probably the last slide I have here, gain harvesting. What if we have a lot of gain? Are we going to allow ourselves to, let's say, go into 2021 or 2022 and not sell those assets? And now we sell them in the future at a much higher capital gain rate. So there's an analysis here to think about. If we have low basis assets that we were thinking about selling, perhaps we sell them now while capital gains are very low. But this is not something that is one size fits all, because when we sell these kinds of assets, there's a trade-off. And the trade-off is that we harvested the gain, but we also took the asset out of an investment, and we also accelerated the payment of income tax, which normally we would not do. So there has to be an analysis here about whether gain harvesting would make any sense. And with that said, I know that's a mouthful. Use this presentation as a tool, use it as a resource, study it, let us know what your questions are. I'm going to turn it over to Jeff, and happy holidays to everyone as we continue with Michael's presentation. Take it away, Jeff.
Let's first start off with a basic review of trust. A trust is an agreement or a contract that you enter into with yourself, assuming that this is a revocable living trust. On the one hand, you have the person who's creating the trust. That person's called a trust maker. Some attorneys call that person the grantor or the settlor or the trustor. I like to use the term trust maker. You enter into this agreement with someone who'll be in charge of the trust. That person's called a trustee. And every trust agreement has a beneficiary. Now, a trustee is a special position of trust. A trustee is known as a fiduciary. A fiduciary is a person who owes the highest degree of trust and competence to the beneficiary. The trustee, as a fiduciary, owes the highest degree of good faith to the beneficiary of a trust. Basically, you have to treat the person's assets and the assets in the trust better than you would if they were your own assets at all. It is the highest and strictest duty of care owed to a beneficiary under United States law. Now, if you are a trustee for a trust and the trust maker of the trust becomes disabled and you are designated as a successor disability trustee, you've got some things that you need to do. First of all, if you're a disability trustee, you have to determine whether or not the trust maker is disabled under the terms of his or her own trust. There are different circumstances under which somebody might be considered disabled. The most common circumstance is a medical circumstance, whether you have a physical or mental disability that causes you to be unable to manage your financial affairs. That is the general standard of law in Maryland to determine if somebody is disabled. There are different ways that your trust can dictate whether or not you fall under this circumstance. First of all, some trusts will say that if two doctors certify that for some physical or mental disability, or a combination of the two, you're not able to manage your affairs, then you're considered disabled and the disability trustee can take over. Others like the idea of what I call a disability panel. The panel would consist of your primary care physician, a second physician recommended by your primary care physician and approved by your then acting healthcare agent. And the third person on the panel would be whoever you have determined in an appointment of a healthcare agent as your healthcare agent. So it would be three people on the panel: your primary care physician, a second physician, and also usually a family member. Now, if all those three people determine that you're not able to manage your affairs, then your disability trustee can take over. But there are other circumstances under which one might be considered disabled. You may go missing for some period of time. Many of you may know the story of William Colby, the former head of the CIA, who went missing for 2 or 3 weeks before his body was found. During that period of time, nobody could probate his estate because they could not prove that he had passed away. You could file for a guardianship of somebody who's missing, but that takes several months. So during this period of time when he was missing, his estate came to a standstill. And that could cause problems to a family if the assets that are in the family are owned by the disabled trust maker. So in the trust, you can state that if you go missing for some period of time, you're considered disabled. But not only do you have to show that the trust maker is disabled, we have to memorialize that in some way. If the cause of the disability is a medical event, then what we're going to need to get are certificates of disability from the doctors. And if there's a disability panel, then also a certificate of disability from the individual panel members. If a person has gone missing, usually a missing persons report from the local police department will satisfy the requirement of a certification of disability. But all these things have to be memorialized because when you think about it, if the disability trustee is contacting the bank to make certain decisions or actions regarding the disabled person's assets, or if you're making certain decisions with the disabled trust maker's financial advisor, those financial advisors, those banks doing their due diligence will need to see proof of the disability. Once the proof is established, we now have to memorialize the appointment of the disability trustee. We do that as well with documentation. First of all, the person who has been determined as the disability trustee should sign a document where he agrees to accept trusteeship. I call that document an appointment and acceptance of trusteeship. And secondly, if one is disabled, one would want to sign an affidavit of trust setting forth the key provisions in the trust and the fact that you, the disability trustee, have been designated in that capacity. Once you take over as a disability trustee, the law in Maryland requires that an inventory of all the disabled trust makers' assets be made. That's very important because as a fiduciary, owing the highest duty of care to your beneficiaries, and keep in mind the beneficiary is not only the person making the trust, but if you're disabled and you're no longer able to change your trust, there will be contingent beneficiaries. That is, people who may inherit from the trust after the disabled person passes away. So it's very important that a trustee keep track and make an inventory of all the assets over which he or she will be administering, so that records can be shown later that you've done what you were supposed to do. The law requires in Maryland that all current and contingent beneficiaries be notified. Again, the current beneficiary would be the disabled trust maker, and if the disabled trust maker is married, the spouse. But also, you need to take a look at the trust and see who would inherit once the disabled trust maker has passed away. Those are called contingent beneficiaries. They are also entitled to receive notice. The next thing that the disability trustee ought to do is review all estate planning documents. A thorough review of the trust ought to be made to make sure that the disability trustee understands what must be done according to the terms of the trust. In addition, the disability trustee should review all healthcare documents, because when someone becomes disabled, not only must that person's finances be taken care of, but also healthcare decisions will need to be made by a person who's not able to do so himself or herself. One thing you need to be careful about is that the person who you have designated as a disability trustee of your trust may not necessarily be the same persons that the trust maker designated as the healthcare agents. So take a look at all of the documents, see who are appointed as the healthcare agents, and notify them as well. One important document that is created in any good estate plan in the event of a disability is a power of attorney. A power of attorney is a document that can be signed that allows somebody else to act in your place, sign your name, and conduct business for you. So the powers of attorney ought to also be located, and we ought to make contact with the agents who you have appointed as the powers of attorney for you in the event of a disability. And finally, we want to take a look at all the assets that are in the trust, not only make an inventory of them, but see whether or not the assets that are owned by the trust maker are all in the trust. If assets owned by the trust maker are not in the trust, the terms of the trust will not dictate what to do with those assets. Now, with the power of attorney, if a person is disabled, the agent may be able to sign the disabled person's name and ultimately convert or assign those assets into the trust. So it's important to look at the powers of attorney and all assets, whether or not the assets are in the trust. Next, and this is especially important if the disabled trust maker is single, not living with anybody, we need to make sure that the residence is secured. If the disabled trust maker is in the hospital or it's in a rehab facility, the disability trustee ought to make sure that the home is secured. Make sure it's locked up. I've always suggested to clients to get over to the house of the disabled trust maker every day and turn on lights and turn off lights in different rooms every day to look like the house is occupied. Make sure the lawn is mowed. Make sure that the mail is picked up. Put a radio on. Make it loud enough so somebody who is outside can hear what's going on in the house and it sounds like somebody is there. It may be that the best thing to do is contact your local post office and have mail forwarded to the disability trustee until the trust maker is no longer disabled. But the house ought to be secured. Financial institutions at which the trust maker have assets ought to be contacted. And again, the appointments of trusteeship and the affidavits of trust ought to be delivered, copies of them ought to be delivered to the financial institutions. So we need to make sure that all the financial institutions at which assets are located of the trust maker are identified and contacted. Upon a trust maker's death, the role is different. Now, rather than preserving assets for the benefit of the trust maker, we need to settle the trust of the decedent. So the first thing that needs to be done when settling a trust, if you are a death trustee, is to obtain copies of death certificates from the state of Maryland. Now, usually it takes 2 to 4 weeks to get death certificates from the governmental authorities, and often it's the funeral home that gets these. In Maryland, generally, 12 certified copies of death certificates will be issued without any cost at all. But if more death certificates are needed, they can be obtained at a cost. You may wonder why we need so many death certificates. Well, you'd be surprised. If the deceased trust maker has 5 or 6 or 7 different retirement plans, life insurance policies, each one of those financial institutions may ask for a certified copy of the death certificate. If not all assets that are owned by the deceased trust maker are in the trust, we may have to conduct a probate for those assets. Now, usually, if you have a trust and you're dealing with a good estate planning attorney and also a good financial advisor, all these assets are correctly aligned with the trust, but sometimes it doesn't happen. So for those assets, we need to identify the assets that should have been in the trust but are not. And we need to get death certificates for those assets as well. The next thing that a death trustee ought to do is review the trust, make sure that the death trustee understands the terms of the trust and see what is involved. In addition to reviewing the trust, the will ought to be reviewed as well. And again, we want to make sure that all the assets that the deceased trust maker owned are correctly aligned with the trust to determine whether or not the assets have to pass through probate. All assets owned by the deceased trust maker need to be identified, and we need to obtain dates of death values for each of those assets. And that's really important for a couple of reasons. Steve mentioned earlier about the step up in basis. Assets that were owned by the deceased trust maker have what is called a cost basis. In plain English, what did the asset cost when you purchased it? If an asset was purchased for, say, $100, but when the deceased trust maker passed away, that asset was worth $200 or $300, all those assets for the benefit of the beneficiaries will receive a step up in basis, thereby wiping out possibly years of capital gain. So it's important to get the date of death values for the assets. Now for real estate, we'll need to get appraisals of the real estate. For assets that are tangible personal property, that is for household items, you'll most likely need to get appraisals of those assets as well. For investments, what we'll need to do is contact each financial institution at which the assets were located and have those financial institutions provide date of death values for each of them. For any bank accounts, we'll need to get bank statements from those banks that show what the date of death value was for each of the accounts. For life insurance policies, again, the life insurance companies at which the policies are located must be contacted. Usually for every life insurance company, they have their own proprietary forms that need to be filled out in order to claim the benefits. So it's very important to find out from each life insurance company what it needs to process any death claims. If you own a business upon your death, that can be involved because what we need to do is establish the value of the business. And in that case, we need to get a special appraisal from somebody who performs business valuations. Sometimes certified public accountants can do that. Other times we may need to bring in a person who specializes in business valuations. Now, just a caveat, a person who does business valuations, they charge a lot of money for these things. They can run several $1,000s. So if we can get a business appraisal by a CPA who can do it, usually that's a somewhat less expensive way of getting the business appraised. If there are savings bonds, we need to establish the value of those bonds as of the date of death. Now, you can go to the U.S. Treasury website, and if you plug in the serial number, the series type, and the face amount of the bond, you can actually get a printout from the Treasury Direct website as to the date of death value for savings bonds. Next, the death trustee has to notify all qualified beneficiaries of the trust. Qualified beneficiary is usually somebody who's 25 years of age or older. And in this notice to the qualified beneficiaries, each beneficiary, upon request, is entitled to a copy of the trust. They are also entitled, upon request, to annual accountings of the trust. In addition to that, the qualified beneficiaries must receive notice from the death trustee as to the identity of the trustee, including the name, address, telephone number, and I usually also include the email address. Once all these things are done, what we now need to do is convert the assets that were owned by the trust maker into what we call an administrative trust. Now, this is not always necessary. For the death of a first spouse, if the spouse was married, sometimes what we will do is simply settle the trust by converting the assets into the marital trust that's created for the benefit of the surviving spouse. But sometimes that's not the case, and almost always when the person is not married upon death and there are two or more beneficiaries, we need to basically create what I call an administrative trust, a trust that's created for the limited purpose of settling the decedent's affairs. What that would involve is getting a federal tax ID number for the administrative trust. Tax returns will have to be filed during the lifetime of the administrative trust, because once the trust maker passed away, the trust became irrevocable. And any irrevocable trust is a separate taxable entity, would have to file tax returns, thus the need for obtaining a federal tax ID number for an administrative trust. Generally, what I recommend, especially when the decedent is not married or is a surviving spouse, is to liquidate all assets as soon as possible. Why do I say that? Because there is a date of death value for assets. Investments over time can either appreciate, that is, gain in value, or they can depreciate and end up losing value. It's the obligation of a fiduciary to preserve assets and not grow them. So if you are trying to be as cautious as possible for the benefit of the contingent beneficiaries of the trust, what we want to do is liquidate the assets, convert them to some type of a cash account or maybe certificate of deposit as soon as possible to minimize the chances that between the date of death and the time that the trustee takes action, there's no depreciation in value, because the fiduciary would have to answer to the beneficiaries if there's a depreciation in value of assets during the course of settling the trust of the decedent. We want to make sure that all creditors get paid, all administrative expenses get paid. So during the period of time when the trust is being settled, we have to identify who are the creditors of the trust, of the trust maker. Were there any credit cards? Were there any debts? Were there car payments? Was there possibly a mortgage on the house? All these things have to be paid. There will also be administrative expenses of settling the trust. First of all, an accountant would have to be retained to file income tax returns. Appraisals usually cost $400 to $500 for real estate. Again, for a business, the valuation could cost far more than that. And of course, the most important administrative expense of all are the attorney's fees. We always want to make sure that if we're settling a trust, the attorney is kept very happy, because attorneys usually have spouses to whom they must answer when they go home at the end of the day. There may be estate tax returns that have to be filed. Now, Steve mentioned earlier that currently the exemptions under federal law are a little bit more than $11.5 million a person, and under Maryland law, $5 million a person. And if you are married, it's twice that amount. But in order, if a person passes away and is survived by a spouse, even though there may not be an estate tax due, you may want to file an estate tax return anyway. Remember what Steve said, that there is a step up in basis when somebody passes away as to the assets that the decedent owned. So let's assume that a husband passes away There's now a step-up in basis for all the assets that he owned, which most likely will be funded into a marital trust for the benefit of the surviving spouse. In order to get possibly a second step-up in basis, when the surviving spouse dies, for the benefit of the children, even though there may not be an estate tax exposure at all, an estate tax return would need to be filed so that the CPA who's filing the estate tax return can check the box called a QTIP, QTIP election, which stands again for Qualified Terminal Interest Property. And if the CPA makes that QTIP election on an estate tax return, not only will there automatically be a step-up in basis for the assets passing into the marital trust, but later when the surviving spouse dies, there'll be a second step-up in basis on assets in the marital trust at her death for the benefit of the ultimate beneficiaries. So we need to make sure that not only income tax returns are filed, but very possibly an estate tax return if the decedent is the first spouse to die. And then ultimately, when all the expenses are paid, when all the tax returns are filed, assets, the net assets in the trust or the estate will then be distributed to the beneficiaries. Now, one thing I want to caution you, and that is this. Generally, the death trustee is not personally responsible for the payment of income taxes owed by the decedent. However, if you are a death trustee and you distribute assets to beneficiaries, and it turns out later there was an income tax liability that wasn't paid, you could be responsible for the non-payment of income taxes to the extent that you've made distributions to beneficiaries. So to protect yourself, and if you're the death trustee, we always want to make sure that all income tax returns are filed and all income taxes are paid before you make distributions to the trust beneficiaries. So as far as managing the trust finances are concerned, we want to make sure, again, that all assets are analyzed when a person passes away, and that's usually done in conjunction with a CPA. We want to see, first of all, which assets are going to appreciate more or appreciate less. That might determine during the lifetime of any post-mortem trust for the benefit of the beneficiaries, which assets should be liquidated and which assets should be kept. Second, keep in mind that when an asset is distributed into a trust at the beginning and the trust is funded, that's called the principal of the trust. The assets that get into the trust upon the death of the decedent is the principal. Then what income that principal produces in at least a marital trust is distributed to the surviving spouse. So a core concept of making sure that income tax returns are correctly filed for a post-mortem after death trust is to keep track of what is principal in the trust and what is income. That is usually something I give some primary advice to any death trustee of a trust. But really what you want to do is work in conjunction with the CPA, because it's a CPA who will be filing all the income tax returns. What we need to do, though, is balance the needs of income beneficiaries with the remainder beneficiaries. What do I mean by that? You may have a trust that benefits a person during his or her lifetime. There may be contingent beneficiaries after the lifetime beneficiary passes away. So generally what a trustee needs to do is balance the needs of the then current trustee, the then current beneficiary with the beneficiaries who will inherit after the lifetime beneficiary passes away. So what we need to do also is determine, if you're the death trustee and you're now the trustee of a trust that goes on for some time for the benefit of a beneficiary, what type of distribution patterns are in the trust? What does the trust say as far as how assets will be passed out? The income is pretty straightforward. I've generally suggested to clients who are death trustees that you almost always want to distribute all the income of the trust to the beneficiary. And the reason is, if you distribute income to the trust beneficiary, the income of those assets will be taxable on the beneficiary's income tax returns, as opposed to it being charged to the trust itself. There are different types of investor rules if you're a trustee. There's something called the prudent person rule and the prudent investor rule. The prudent person rule basically restricts the investments to conservative, low-risk assets. I'm a pretty conservative person when I provide advice to a death trustee. I usually recommend that when it comes to investments that the trustee use the prudent person rule. Much less likelihood that the trustee might get into trouble later if assets tank. There is also something called the prudent investor rule. That incorporates modern portfolio theory, but generally you need to make an election to be governed by that rule. Again, my suggestion always, if you're a trustee of a trust, for somebody who's already passed away, I like to be conservative in my advice. I generally recommend the prudent person rule and use very conservative vehicles for the assets in the trust. Different trusts have different distribution patterns as far as how to provide for the beneficiaries. Some trusts require all the income to be distributed to the beneficiary. That's called a simple trust. Pretty straightforward. The income gets paid to the beneficiary, and then the income often as and when needed. The standard under the IRS code is health, education, or maintenance. Now, how does the principal get paid? Well, there's one type of a trust called a uni trust. That is a trust in which the distributions of principal are based upon a percentage of the assets in the trust on an annual basis. So if the uni trust says that all income will be paid out plus 6% of the principal, that's the amount of principal distributions to be made to the beneficiaries. Some assets allow a beneficiary a certain right of withdrawal. They're entitled to take out a certain amount on a regular basis. Some trusts basically say that at different age gradations, for instance, at age 25 or 30 or 35, that the beneficiary is entitled to receive either a specific dollar amount or a percentage of the principal in the trust. So we need to take a look at the distribution language in the trust to see if it's a unit trust, if there are any rights of withdrawal, or if there are any age-specific distributions. So sometimes a trustee is provided, as far as the principal, complete discretion. That's often done for a beneficiary who is a special needs beneficiary. They may be receiving government benefits, and in order to make sure that beneficiaries are not disqualified from those government benefits, if you want to provide for such a beneficiary, you give to the trustee total and absolute discretion. In such a case, the trustee is entitled to give all of the assets or zero of the assets during the entire lifetime of the beneficiary. Again, one of the standard discretionary standards is subject to health, education, maintenance. Some lawyers use health, education, maintenance, or support. There may be other restrictive language in the trust. If you're providing for a beneficiary who has some substance abuse problems, maybe alcohol addiction, drug addiction, a gambling addiction, there may be limitations on distributions during any such period of disability. It's the trustee's responsibility to review the trust completely and determine whether or not there are any other types of restrictive language in the trust. Again, trustees are responsible if they fall below the standard of care for a fiduciary. So we need to take a look at the language in the trust as far as what your liability might be. Again, we want to review the trust agreement. Are there any indemnity provisions in the trust? Does the trust provide any type of indemnity if he or she does not perform perfectly while he or she is the trustee? We need to take a look at the standard of liability that might be dictated in the trust and also the local laws regarding standards of liability for trustees. So my suggestion, if you're a trustee, is protect yourself. Provide annual accountings to the beneficiaries. Don't wait for them to ask for them. If you're providing annual accountings to beneficiaries, showing what is in the trust at the beginning of a fiscal year and what is in the trust at the end of a fiscal year, and provide to the beneficiaries accountings, what I have found is the most important thing is communication. The more you communicate with the beneficiaries, the less likely there'll be problems later. If you're going to be making any considerable distributions, let's say a trust provides that now at the end of a certain period of time, all assets in the trust are being distributed to the trust beneficiaries, I've always suggested the clients get releases from the beneficiaries where they agree that they have read the inventories, they've read the accountings, they've understood them, they've had the opportunity to review all these documents themselves, they've had the opportunity to review these documents with attorneys of their choice, and they've either done so or have voluntarily waived their right to do so. Have them sign a release that says that they are in agreement with the final distribution pattern. I've also just suggested to death trustees, when the release is signed, have each beneficiary have a provision in the release where they hold harmless and indemnify the trustee for any future unknown income tax liability there may be for the trust that was not known at the time of distribution. So if later the IRS or the Comptroller of Maryland catches up and discovers some long-standing tax liability that you as the trustee did not know about, each beneficiary has agreed to hold you harmless proportionate to the assets that they've received from the trust. And if possible, and this would be a legitimate expense of the trust trust itself, obtain a trustee liability policy that would hold you harmless in the event that a beneficiary later has an argument or a problem with what you've done and tries to seek relief from you. A qualified beneficiary, again, that is defined under the Maryland Trust Act. The notice requirements for a qualified beneficiary is 90 days to tell qualified beneficiaries that a trust has been irrevocable, and 60 days to notify all of the qualified beneficiaries that you have been appointed as the trustee of the trust. These notifications cannot be waived. Thus, we cannot have what we call a settlement of a quiet trust in Maryland. These notices must go out. And again, we went over these rights of a qualified beneficiary earlier. They're entitled to receive a copy of the trust. They're entitled to receive annual reports and a final report upon the termination of a trust. Trustees are entitled to make commissions. Under Maryland law, there is a formula that says how much a trustee is entitled to be paid. You cannot be paid more than what the formula allows for in Maryland unless you are a corporate trustee. In Maryland, a corporate trustee is entitled to be paid commissions based upon their published rates. If there are multiple individual trustees, then what happens is we would figure out what the trustee commission is and split them in an equitable way among the multiple beneficiaries. So again, there are statutes that cover how commissions ought to be paid. There are grantor and non-grantor trusts. A grantor trust is a trust that's created by the beneficiary himself or herself. A non-grantor trust is a trust that is created for the benefit of somebody else. Michael, in a few minutes, will talk about how the income tax returns for grantor and non-grantor trust will be handled. So what I'm going to do is, I know we're running out of some time now. I know that we want to give Michael an opportunity to go over these different standards and requirements for various types of trust. So I come to the last slide, which says thank you. So in conjunction with that slide, thank you, welcome this morning. We hope you have enjoyed it so far. Michael's going to give you some very helpful information next about income tax returns for trusts.
Well, thank you, Gary. Well done. And are there any questions for Gary at this time? And actually, we do have a question from Nancy from our firm. Thank you, Nancy. Nancy asks Gary, what is a quiet trust?
That's a sort of a term of art. A quiet trust is a term that came up with when a trust is being settled, the beneficiaries are not getting full notice of what's going on. In other words, before the Maryland Trust Act was signed, there were no requirements that beneficiaries be given the rights to receive copies of accountings or inventories. So lawyers call that a quiet trust, a trust that's being settled without full knowledge and disclosure to the beneficiaries. So the Maryland Trust Act was designed to prevent the settlement of quiet trusts.
Good question, Nancy. Thank you. Any other questions before we take just a 2 or 3 minute break, and then we'll have Michael jump on here? No? Okay. How about if we take just about a 3-minute break? We will start back on time in 3 minutes. Thank everybody. It's our final break for the day. And we'd like to welcome Michael Joseck from Elville and Associates, who's going to go through some tax fundamentals and tax mechanics and estate planning and estate administration. So welcome, Michael. Looks like you have your presentation up. If you want to share your video and audio, be in good shape. There you are. Hi, Michael.
Hi, Jeff. Thank you for the introduction.
All right, my pleasure.
Good morning, everyone. I hope everyone had a lovely holiday. And as Jeff, Gary, and Steve were saying, I'm going to be discussing tax fundamentals associated with both trustees and estate planning. So this is going to actually go into a little bit more depth on what both Gary and Steve were explaining. So what we're going to learn are the tax fundamentals, tax mechanics in estate planning and estate and trust administration. Specifically, here's a list of the taxes that we're going to be covering and some of the most important taxes that you're going to be covering with some of your estates and trusts. So specifically, income tax or your fiduciary income tax. Now, this is important because this is one of the most unknown taxes that a fiduciary may have to deal with. Typically, what I've experienced is that whenever a trustee handles the taking over of a trust, that they are commonly referring to the income tax as the estate tax. But that is not always the case. The estate tax is actually an entirely different tax, and I'll be covering that later in the presentation. Whenever I'm discussing the estate tax, I will also be discussing the Maryland estate tax, the concept of portability, and also Maryland inheritance tax, which is a state-specific tax. So income taxes for estates and trusts. What we're going to be discussing are the actual forms that you need to file, when these will need to be filed, the role of the fiduciary that Gary was describing, the tax rates, some additional information you'll need, and steps to consider. So what is the fiduciary income tax return? The fiduciary income tax return is the IRS Form 1041 is the necessary form that must be filed with the IRS or the respective state agency. So with the respective state agency, you're going to find out as the trustee or as the personal representative of the estate, which form needs to be filed with that state. So for instance, in Maryland, the respective form is Maryland Form 504. Now what this does is that this reports the state income to the state taxing authority, and then the return will determine whether or not a tax needs to be paid. And for Maryland's Form 504, it must be filed with the Comptroller of Maryland. So knowing where to and when to file these respective income tax returns with the respective federal and state governments is crucial, because as you'll see later in my presentation, they may not always need to be filed on April 16th, which is tax return day. So basic principles. A trust for a decedent's estate figures its gross income in much similar to the same manner as an individual's personal income tax returns. So what I'm trying to say is that similar to an individual's personal income tax returns, you're receiving almost every February or January, you're receiving tax return information from the respective institutions, such as a 1099 or other financial documents that you need to report the taxable income or gross income on the tax returns. And what this will tell you is this is how much income was reported on this asset. Then from there, similar to your personal income tax returns, most deductions and credits allowed on an individual tax returns may also be allowed on estates and trust income tax returns. And why is that so crucial is because if you've already been preparing your income tax returns, then you can understand somewhat how these returns are laid out. you have your gross income, and then you'll have your deductions that or credits that need to be taken away from the gross income. But the major distinction that Gary had highlighted during his presentation is the income distribution deduction for distributions to beneficiaries, and how this is crucial. How this is so crucial to the income tax return is this: as the fiduciary of the estate or trust, you may be trying to determine whether or not it's best to keep the income to minimize the income that's being distributed to an income beneficiary, or whether or not the income should be kept into the terms of the trust and allowed to grow. So there's a lot of factors to go into whether or not all of the income should be distributed to a beneficiary, or whether it's advantageous for an individual to receive that income for their own personal tax returns. So for instance, with a special needs trust, it's not always beneficial for the income to be distributed out for a beneficiary. So even though the income, all of the income in the trust may not have been utilized during the course of the year, you don't want to utilize the income distribution deduction and distribute that out to the individual with special needs, because that actually might harm some of their benefits. So it's going to then come down to keeping that income into the trust and not utilize the income distribution deduction. But I'm only using that special needs trust as an example. It depends on the type of trust, the terms of the trust, and how the distribution is to be handled to the specific individual and that individual's specific circumstances. So it's not always just a clear-cut answer. It does require a good bit of analysis by the fiduciary prior to utilizing an income distribution deduction. So additional basic principles are the types of entities, which are the decedent's estate. So again, an estate of a deceased person is a taxable entity itself and is separate from the actual decedent. And it generally continues to exist until the final distribution of the assets of the estate are made to the heirs or beneficiaries of the estate. Now, the income earned from the property of the estate during this time period of administration or settlement must be accounted for and reported by the estate. And during the course of the accounting period, it's a very specific account that's being handled by the fiduciary. It's keeping track of not just the credits and debits, but you're categorizing the credits and debits into whether or not this was a cost and expense of the estate or whether or not it was an actual distribution. And that's always a crucial aspect for the fiduciary to be examining against not only the terms of the instrument itself, such as for a decedent's estate, the will, or possibly the trust, but also collaborating with the tax professionals on how this should be categorized to optimize and take advantage of whether or not the income should be distributed to an individual. So next, the income earned from the property of the estate during the period of administration or settlement must be accounted for and reported by the estate, meaning that not only is it accounted for, and as I had just discussed, but it's also going forward and ensuring that this is handled properly and reported properly to the governing state bodies. Trusts. Depending on the type of trust, the income may be distributed out. Now, as Gary highlighted, there's two types of trusts and that may be taken advantage of. It's either a grantor trust or a non-grantor trust. And depending on the type of trust, which I'll highlight in the next slide, the income may be reported on a grantor's personal income tax return, but that may not be the case. And that's why it's always crucial to collaborate with your tax professionals to determine whether or not the income is for specifically a grantor trust is to be reported on the grantor's tax return. So who must file and when? So as the fiduciary, either the personal representative or the trustee you will have the responsibility collaborating with your tax professionals on filing the tax returns with the appropriate state bodies, which I had highlighted earlier, either the IRS or in Maryland, the Comptroller of Maryland. So for trusts, whenever the gross income of a trust exceeds $600 or more, a tax return is required to be filed with the IRS and the Comptroller of Maryland. Or a beneficiary is a non-resident alien. And it's usually any taxable income for the taxable year. So in order to determine the taxable year, it's a trust tax return is reported on April 15th. And trusts typically go by a calendar year tax period, meaning that they follow typically from January until December 31. That is going to be your taxable year, and where all of the income distributions, disbursements are captured on, as we previously discussed, the accounting for the trust. Now, what that means is that come April 15th, you will need to file your the 1041 and or the 504 with the respective tax agencies, unless you file an extension. Now, for the grantor trust, I highlighted this because a grantor trust may not need to file an individual return, meaning that if you've set up a grantor trust, such as a revocable trust, then you're already reporting the income on your own personal tax return. Now, there are other grantor trusts besides a revocable trust where, in that instance, the income may be attributed to the grantor, but an EIN has already been obtained, meaning that the trust has already been set up as its own separate entity. And what happens is that you still want to claim the income for the grantor trust. In that instance, what you would do is that you would file a tax return with the IRS, but you would actually include a special statement stating that all income is to be reported to the grantor. Because what's happening is the EIN for the trust was obtained, meaning that the IRS has recognized that this trust exists and that this income has been reported to this grantor trust. However, the grantor trust doesn't want this reported on the trust tax return. It just simply wants it reported on the individual's return. Now, what will happen is that this will defeat having to file multiple returns with the IRS, and it keeps it actually more streamlined. So what you're just simply doing is just simply saying, I just want all the income reported to this EIN actually attributed to my Social Security number. And it's a fairly straightforward process, but it just depends on the type of grantor trust that has been established and what your tax professionals and you as the trustee or grantor have determined on how to proceed forward. Now, for estates, again, estates where the gross income of the estate exceeds $600 or more, or the beneficiary is a non-resident alien, means that the 1041 or in Maryland, the 504 needs to be filed with the respective taxable agencies. Now, for the estate, that doesn't mean that the 1041 or the 504 is to be filed on April 15th. So this is unlike the trusts, because estates may be set up on either a fiscal or calendar tax period. So what this means is that you can actually set this up so that the tax return is filed prior to the April 15th deadline, and this can finalize the estate's the return for the estate in a much quicker fashion. So the information that you need to prepare either the 1041 or the 504, here I just simply stated the 1041 simply because there may be tax returns due in other states, but the principle carries over across to multiple states. So the information that you'll need is a copy or prior year's fiduciary income tax return if one was actually filed. So if this is the first year of the trust or the first year of the estate, you should definitely consult with your tax professional regarding how to prepare this, because this is, although it's very similar and the concepts are very similar to a 1040, they can, as I pointed out and discussed earlier, utilize an income distribution deduction, which you may or may not want to carry forward. And you usually utilize a copy of the prior year's return to see how this was handled in previous years. But if this is the initial year of the return, it's recommended that you discuss and seek advice with a tax professional to see how the instruments are analyzed and how to move forward with that, all of the circumstances surrounding that actual distribution, or whether it was a distribution itself. You'll also need a copy of a final 1040 if one was done. So for instance, for an estate, you would need a copy of the individual's final 1040 so that you can properly determine, as the fiduciary or personal representative, when the income ceased, and for the individual's personal 1040, and when it would be picked up on the estate. You would need the EIN of the estate and or the trust, a copy of the instruments or the copy of the will and the trust. If the individual has passed, then you're going to need a copy of the death certificate, the beneficiary or heirs tax information. Now, what I'm saying here is that if you're utilizing an income distribution deduction, what's going to be issued to the individuals is what's called Form K1. Now, this Form K1 requires the individual beneficiaries or heirs' Social Security number, meaning that you need to receive their Social Security number to place on the Form K1 that you're then issuing to these beneficiaries or heirs. And it's crucial that you receive that information. And you should be entitled to it and receive it as the fiduciary during, especially due to the fact that you're required as and tasked with the duty of preparing these tax returns as the trustee or the personal representative. You'll also need copies of all 1099s issued to the decedent and or the trust. So these are the typical income statements that you will be receiving in either January or February of that year. And this will inform you on the income that was received by the trust or the estate. Now, it's crucial to always examine the 1099s because, as in my experience, you want to ensure that, as Gary and Steve were discussing earlier, that if an individual has passed, that the proper cost basis or step up in basis has been utilized for either the decedent's estate or the trust, depending on the circumstances surrounding the trust. So that's why it's always crucial that the individual trustee or personal representative carefully examine these 1099s, because otherwise you may report the income that was issued on the 1099 and then be required to report more tax than is necessary, or be required to pay any tax that you shouldn't be required to pay. A copy of the probate inventory and the probate accounting. Now, why these are important to receive is because the probate inventory, as Gary was discussing, reports the actual date of death balance of the assets in the estate that are carried, and the cost basis for that going forward in the estate. So whenever preparing this, then you'll know how to actually compute the capital gain or loss on an asset once it's sold. Now, the actual keeping of the probate accounting and why it's crucial in keeping that is because that's where you're keeping track of the credits, the debits, the interests, any gains or losses that have been experienced by the account or the trust. And that's just going to be the best place to know on what the total activity on all the trust assets or the estate's assets were for that year. Again, I mentioned this whenever I was discussing the probate accounting, but the annual trust administration account. For both the probate and the annual trust administration account, you're just keeping track of all of the activity regarding the probate or trust assets. And it's just crucial to just keep as comprehensive of records as possible, because it'll just make everything at year end a lot easier. There's too many times where we're going through and advising a fiduciary and constantly requesting more information on the types of checks that were issued, the payments that were issued, to whom payments were issued, or additional details. If you're able to provide as much detail as possible on these accountings, then what's going to happen is, if you're preparing this as the fiduciary, it'll make this so much easier on yourself. But if you're working with a tax professional on the preparation of the income tax returns, it's actually going to help minimize the cost, because what's happening is that then the tax professional isn't required to constantly go back and forth between yourself and the fiduciary and your personal records and what's happened with all of the transactions regarding the trust. So that's by keeping an accurate accounting and all accurate receipts regarding the trust asset, receipts, statements, invoices, etc. You're actually making this a cost-effective matter going forward. K1s from entities. So by the K1 from entities, what I'm discussing is if the trust or estate was the beneficiary of income from a partnership or these corporations, then you need to provide this K1 to either maintain the K1 or provide it to the tax professional so they can report the income that was received from this entity on the respective 1041. The bank and investment statements. These are also crucial because, again, in my experience, what I've seen is that sometimes what you'll receive on the bank and investment statements doesn't always match up with the 1099s that were issued by either the financial institution or the brokerage house, etc. I've seen instances where the request for the step up in basis or the date of death value was not actually reported, meaning that the 1099 that was issued to the fiduciary actually reported rather substantial capital gain. So by reviewing these bank and investment statements and the 1099s that were issued with your tax professional, or knowing how to address this now, would help you just try to mitigate the possibility of an unnecessary tax liability as the fiduciary of the trust or the estate. So again, my last point is consult with professionals on additional items. So if you receive something that may not be on this list, or if you feel that there's something here that you're not entirely sure on how to handle, don't be afraid to consult with the tax professional, because as the fiduciary, this is one of your highest duties, is to ensure that these tax returns are filed with the IRS or the respective state agency. So next, what I had was, why don't individuals or fiduciaries file the fiduciary income tax return? So individuals or fiduciaries know that a final income tax return must be filed for an individual that has passed, but they may not know that they need to file a tax return for an estate or a trust. So for instance, anybody that's a personal representative or an executor will know that they have to file the individual's final personal income tax return, but they may not receive the advice that, or know, especially if they're taking this task on their own without consulting a tax professional or such as an attorney or a CPA, that they need to file a tax return for the estate as well, or that one should be assessed on whether one needs to be filed. And what that could result in is potential liability on either the personal representative or the trustee. So my next point is, typically after creation of a trust, the fiduciary is obligated to file the return. When the fiduciary is unaware, the return will not be filed, which creates multiple problems later on down the line. So depending on the type of trust and the circumstances surrounding the trust, a return may not be required to be filed. So for instance, as I was talking about earlier, a grantor trust may or may not be required to file a tax return. But if a fiduciary has decided not to file the tax return and multiple and several years have passed since that return was required to be filed, as Gary was discussing, this could pose a potential liability where the trustee or the personal representative has then created a breach of a fiduciary duty and may be personally responsible for fees, expenses in order to rectify this. The other issue is that the fiduciary income tax return is a very often a misunderstood return, just because there's so many different perspectives that needs to be taken into consideration. Whether or not the individual's return needs to be utilized with the matter, such as with a grantor's tax return, the review and understanding of the actual instruments involved, such as the terms of the trust, determining whether it's a simple or complex trust, and the income and how that's reported. It's very often that the fiduciary income tax return is not understood by the fiduciary themselves. Often, additionally, there's 19 years between follow-ups and visits on the evaluation of estate plans. So for instance, an individual may establish a trust that's required to file tax returns for its entire existence, such as, for example, the possible creation of an ILET that Steve was discussing. There may have been the requirement that a tax return should have been filed during that entire existence of the ILET, but the trustee or fiduciary has never filed that tax return. And then 19 years later, the individual comes back and reviews their estate plan, and they've determined that a tax return should have been filed for that trust the entire time period, or it should have been filed just to create some sort of record with the IRS, but that was never done. What this will ultimately create, and which I'll discuss on my next slide, is this will create substantial fees incurred by either the trustee, the grantor, or the individual themselves, depending on the issue or matter that has been created for failure to file the tax return. So again, why people don't file and possible outcomes. So meaning people haven't filed this and the results haven't filed the income tax return, and the issues that result are it's extremely costly for a tax professional to go back in time to prepare, amend, fix, and file numerous fiduciary income tax returns on behalf of these specific entities. So it's actually going to be extremely costly. Rather, if this was just done quickly in the beginning while the matter was being addressed at that time, such as the decedent's estate was being administered during that year, or the trustee just reached out during that tax year to discuss with a tax professional to determine whether or not a trust tax return needed to be filed. It's time consuming to both the fiduciary, the personal representative, the executor, or the trustee, and the tax professional themselves to locate the necessary information to prepare the returns. So if extensive time period has passed between when the return was actually needed to be filed, again, this goes back to it being extremely costly. Then the tax professional has notified the fiduciary that they needed to provide this tax return to the respective tax agencies, and the records are no longer in a organized manner, and the fiduciary will then be spending countless hours trying to go back and rectify this issue. So if these matters were just addressed in a timely fashion or discussed with the tax professional at that immediate moment, then this would avoid a substantial cost to either the estate or the trust. The next point is the amount of time between tax filings or whenever the individual should have filed it may trigger additional tax filings respectively. Sure. The gaps in information may result in additional liability to the estate or trust with interest and penalties. So just be cognizant of that. So what I've posted here is just a comparison between the individual tax rates and the estate and trust tax rates for the individuals. And this goes back to whether or not how the fiduciary should determine whether or not to distribute to the individual, such as an income distribution deduction, or whether or not to distribute or to keep the tax in the trust itself. I understand that we're running out of time, but I just want to cover some of the estate tax principles quickly. So again, what Steve had mentioned was the unprecedented amount of times, the exemption amounts, Maryland planning, portability, the deceased unused exemption amount, marriage exemption. So the estate tax return, the forms to file, when to file, tax rates and exclusion amounts, what information you'll need, and steps to consider. So the overview of the estate tax return is it's a tax collected on the transfer of the individual's assets that pass to heirs and beneficiaries after the death of the individual. It's the total estate tax due is calculated by adding the fair market value and the gross estate and taxable lifetime gifts exceed the basic exemption amount on that year of death that a tax may be owed. So in order to determine that tax, again, you're going to consult with your tax professional. To determine your gross estate, you're going to be, I'm just highlighting a slide of what everything takes into consideration. So all of these matters will be taken into consideration regarding the computation of the gross estate for the estate tax return. Additionally, this slide just highlights the types of non-probate assets. Again, the unprecedented exemption amounts that Steve had been highlighting earlier, and for currently it's 22 million for married couples. Each year, the IRS adjusts the exemption amount for inflation. So the return forms to file for the federal, the IRS form is the 706. For Maryland, the form is the MET 1. So I know that Gary was talking about having a CPA prepare the returns for you, but I strongly encourage you to have an attorney review the returns as well to ensure that the terms of the instruments are such as the will and the trust are put into place and that the proper selections are made by that CPA or tax professional before submission to the IRS or to the Comptroller of Maryland to ensure that this is done correctly. Just because sometimes I found that the CPA is not always entirely conversed in all of the terms of estate planning. This slide right here just reflects the years of the federal tax exemption and how it's just increased over the substantial periods of time. And then how in 2026, as Steve was discussing, will then drop down to the 5.4 million mark. Each year, the tax rate during this time period has remained at the consistent rate of 40%, which is an extensive tax rate, and why it's always advantageous to do your proper tax planning now to try and ensure that you're not receiving a 40% tax on your estate. This note right here is just the 2021 exemption amount that Steve was discussing as well. But the difference is that the married couple should be able to shield up for 23.4 million for next year. So this was already released by the IRS and what we know going forward for 2021, unless something should change with the political parties. Now, this slide right here is the exemption amounts for the Maryland estate tax. Again, as you can see, it has gone up extensively over the past couple of years, but for the past 2 years, it has remained consistent at 5 million. And for next year, we're also reflecting a consistent tax exemption rate of 5 million as well. The Maryland tax rate is 16%. And how this works is that the Maryland tax is then able to be utilized with the estate tax. So this slide just calculates, just highlights more on Maryland's estate tax, and the difference between the Maryland estate tax and the federal estate tax is that the Maryland estate tax is based on a resident whose estate includes an interest in real property or tangible property actually in Maryland. So it's only if that interest is available do you need to file the MET 1 with the Comptroller of Maryland. And again, the tax rate of 16% is on the net estate subject to the tax, not the actual gross estate. So when to actually file the estate tax returns, the personal representative or executor of the estate is responsible for filing the tax return within 9 months of the decedent's date of death, unless a timely extension is filed with the IRS. Now that is usually whenever an individual actually has a tax liability, so meaning that they exceed the exemption amount. Now, if an executor is just filing a portability election, meaning that the estate hasn't exceeded the exemption amount, but you're just trying to capture the unused deceased exemption amount and carry it forward or port it over, which I'll discuss, there's a slide on later, then you may have up until the second anniversary of the decedent's death without any tax liability being owed. So again, here's portability, and the portability is the ability of a surviving spouse to reserve his or her deceased spouse unused estate tax exemption. In 2019, a married couple can pass up to $22.8 million in assets to loved ones with no federal estate tax implications, and that's an amazing tool to take advantage of.
Yeah.
So, and it's an easily tax planning method to be done. Lastly, steps to consider. There's no uncertainty on whether the exemption amount will increase to the same level that currently exists. Surviving spouse, consult with your tax planning professionals on whether you should file the portability election to take advantage of any used estate tax exemption. It's a great tax planning tool for all the other couples, for all others, for instance, couples, individuals, and surviving spouses. Consult with your tax planning professionals. And I'm just including a quick slide about Maryland inheritance tax, just about what it is and the tax rate, and you can discuss this more. And my last slide is just the forms themselves that I had discussed previously and their deadlines. And thank you so much for taking the time to hear me. And if you have any questions, please feel free to contact me.
Thank you very much, Michael. I know a lot to cover in a short amount of time. Anybody have any questions they want to pose to Michael before we wrap up and offer out our door prizes from our client event and for being client care program members?
Jeff, are Michael, Steve, and I eligible for the door prizes?
No, I don't think so. Not this year. We decided not to do that this year, Gary. Sorry.
Okay.
There is a question for Michael briefly. Michael, does Maryland have portability?
Yes, it does. So Maryland has allowed portability to go forward, and we've done this. We've filed the portability return for some of our clients. It's a fairly easy and straightforward method. As long as we have all of the necessary information, I encourage you to take advantage of portability if it applies to you.
Thank you. Any other last questions? Okay. Well, with that being said, we appreciate you being here today. I'll be sure to have all the materials as well as the edited video sent out to everybody, including Elville clients and Greenwald clients, I would say by Tuesday. I'm going to send that to our graphics designer and video specialist to get it edited down and sent out to you probably by Tuesday. And now it's my pleasure to announce our door prize winners from our client event. And also we want to thank you for being client care program winners. And so we have a few 12 door prizes. I'm going to go through them efficiently to respect your time. We have, I'm going to start off with 3 Gertrude's gift certificates, $100 value each. And Gertrude is the really excellent restaurant at the Baltimore Museum of Art. If you haven't been, it's a treat. I've been there a few times with our friends at WBJC, and it's really a wonderful place. And we have our winners here. And the first winner is Robert and Carolyn Morose. Congratulations. And we will get this sent out to you. And our next winner for the second gift card of $100 to Gertrude Restaurant is Charles and Arlene Lumpkins. Congratulations. And the third winner for the Gertrude's Restaurant gift card is Bruce and Kathy Keeney. Congratulations. If you haven't been there, it's a treat. You will thoroughly enjoy it. Now, we also have from the Annapolis Symphony Orchestra. I'm sure you're wondering, well, the Annapolis Symphony is not performing. Well, yes, they are. They are performing virtually right now, and hopefully they will be getting back live in the foreseeable future. We have an all-access household pass to the ASO's Symphony 2020-2021 virtual series. So this includes access to all of their concerts that are virtual, ASO chats, live streaming, concerts, concert broadcast replays. It includes a lot. So it's a wonderful door prize. And the first winner we have is John and Roxanne Wheatland. Congratulations. And the second winner, we have two of those. The second winner is Maria D'Souza Dada. So congratulations, Maria. In order to access that all access pass, I need to contact the ASO and let them know your information, and we'll get that pass unlocked for you within the next couple days. We'll get that taken care of on Monday for you. So you'll get some more information about that. Last but not least, we have our popular gift baskets that we always have offered during the times that we've been able to get together for our client events. But this year is no different. So we have 7 gift baskets, and I have a description of each. I'm not going to go through the entire description, but I'm going to try to be efficient and give you an idea of what each one is. We have them here in our office. We will deliver them to you. And the first one is A Taste of Maryland. This Maryland gift box will arrive filled with Chesapeake crab cake mix, 5-piece Maryland-inspired truffles, Mouth Party caramels, Maryland flag crispy cake, Jeppy Maryland nut mix, Fisher's popcorn, and a wooded Maryland flag keepsake magnet. And the winner of that is Jeff Stauffer. I read that wrong. Wait a minute. No, Bob and Ann Slattery. Congratulations. So the second one is Treasures of the Chesapeake Shipper Box. We package our great local finds in this sturdy shipper box. The presentation is beautiful with a large coordinating palm bow on the top of the box. Makes a great gift for someone traveling or a great simple gift, beautifully arranged for your enjoyment. And the winners are Roy and Karen Blay. Congratulations.
Congratulations. Yes.
Number 3, we have a coffee lover's gift tin. We love our coffee here at the office. Coffee lovers will be thrilled to receive this assortment of coffee and pairing treats. Biscotti 2 perfect pot coffee blends, espresso sugar, cookies, coffee candies, and flavored coffee syrup. And the winners are Robert and Bernice Prescott. Congratulations. Next, we have Morning Delights. Enjoy this Maryland Perfect Pot coffee blend along with cookies, biscotti, Walker shortbreads, and chocolate-covered coffee beans. Most days, my Maryland home coffee cup is filled with a mid-morning Harney and Sons tea sachet. This basket includes the best of both worlds, a bonus tin of 10 sachets of blended tea and locally sourced honey. And the winners of that are Song and Virshana Omkar. Congratulations, Song and Virshana. Number 5 of 7 is an Autumn Treats gift basket. You can still enjoy it even though it's getting to be December and winter. This basket is filled with pumpkin spice, caramel apples, so many items that just say autumn. Includes chocolates, apple caramels, pumpkin cookies, apple butter, nuts, crackers, pretzels, popcorn, a perfect mix of all your fall favorites.
Sorry, Gary.
And the winners of that are
My fingers crossed.
Farhad and Mistra Memerzada.
Congratulations.
Yes, I did say that right. Sorry. Number 6, a Taste of Frederick gift bag. I think this is my favorite, one of my favorites. Local Frederick, Maryland favorites. Fashioned in a natural brown reusable burlap tote bag, this basket includes a Frederick, Maryland hand towel, Zoe's chocolate bar, popcorn house, savory popcorn, McCutcheon's sparkling apple cider, and a Frederick, Maryland crispy cake. And the winners of that are Jim and Karen Grafmeyer. Congratulations. Last but not least, number 7 of 7, the Crabs and Beer Bushel.
That one's mine.
Sorry, Michael.
I call it.
That sounds pretty good. That sounds pretty good. Crabs are always good any time of year. Who doesn't love Maryland crabs? I know my family loves them. Even better, chocolate crabs with Maryland brews. Send a little taste of Maryland with the bushel basket filled with chocolate crabs, assorted Maryland craft beers, Old Bay, and a crab mallet. And the winner is Lon and Nancy Brightbill. Congratulations. So congratulations to all of our winners. If you didn't win, there's always next year. There's always other events. And we want to thank you for participating in this event and being members of our client care program and for being valued clients of our firms. So any closing comments by any of our panelists or anybody that's out there in the virtual world?
I just want to say happy holidays and safe travels. If you are doing any traveling at all, if you're staying at home, which most of us are, be safe and well. And we look forward to seeing you in the new year and our upcoming first quarter event in 2021. I want to thank Michael for a great job. This is the first time he's participated in our CCP. Thank you, Michael.
Thank you.
And Gary, thank you. And that's what I have to say. Be well, everyone, and thank you for your commitment. Gary?
I want to thank again everybody for joining us. I actually enjoyed putting this event together. I'm looking forward to the days when we'll be able to do this again in person, but this is the next best thing. So everybody stay safe. We'll see you either in I guess February or so. We're not quite sure when the next event will be, but we're working on the curriculum now. We should have the date announced in the next couple of weeks.
Sounds great. Thanks, everybody. And Michael, now that you presented, you're in the mix, so you're going to be back again soon.
Yeah, you're stuck, Michael. You got to do this again.
Okay.
All right. Thanks, everybody. Have a wonderful weekend, a great holiday season, and we'll see you all again soon.
Bye, everyone. Have a great
Bye.
weekend.